junior senator from Missouri in attempt to rehabilitate the witness. You never say that the right to vote is somewhat secondary or less than any other right. Is that fair to say? And you answered, yes, that is fair to say. I never said that. I have read and reread this. I'm not ready for a question on the final, but I've read and reread your dissent on this. I'd like to read to you what you wrote on this very question asked by the senator from Missouri. In sum, I think we need to establish what this case is about for those who may not know or remember. Ricky Cantor was a con man, lived in Wisconsin. He manufactured some kind of shoe insert, a pad, and tried to sell it to people who had diabetes or some foot problems. He wanted the Medicare to say that it was approved. They didn't. He sold it anyway and made that representation. When it was all over, it came crashing around him. He cheated Medicare out of $375,000. He was found guilty of a count of mail fraud, paid $300,000 in penalties and fines. He paid out $27 million in a civil settlement and then spent a year in federal prison. So this was not some run-of-the-mill miscreant. This was a fellow who was a con artist. He came to the federal courts and said, this is unfair. I've served my year in prison. Now I want to buy a gun. And the law says I can't buy a gun if I'm guilty of a felony. And the court said, sorry, Ricky, you can't buy a gun because you are guilty of a felony. Even the Heller decision. Justice Scalia said that felonies and mental illness could continue to disqualify a person from buying a gun in this country. 2 out of 3 judges who heard this case said, that's right, that's the law. Sorry, Ricky, no AK-47 for your birthday. But then you took a look at it and reached the opposite conclusion and did extensive research and delving into history about whether or not violent felonies should be distinguished from regular felonies. And you concluded that you believed that a person who has just been found guilty or convicted of a felony should not be disqualified from their Second Amendment rights, that should be confined to those who were dangerous, guilty of a violent felony. Here's what you said to go to the question that was asked by the senator from Missouri. Here are your words. In sum, the available evidence suggests that the right to arms differs from rights that depend on civic virtue for enjoyment. The Second Amendment confers an individual right intimately connected with the natural right of self-defense and not limited to civic participation. By the very terms of the civic rights argument, then, the right to arms would have been treated differently than things like the right to vote or sit on juries. So here's what it boils down to. After Heller, after the decision, after Scalia's statement, you concluded that any felony can take away your right to vote, but only a violent felony can take away your right to purchase an AK-47. Why?
Senator, with respect, that's distorting my position. What I said in that case, which is what Heller said and which is conventional in all discussions of this, to my knowledge, is that the right to vote is fundamental. However, it is an individual fundamental right that we possess, but we possess it as part of our civic responsibility for the common good. The same thing is true, for example, of jury service. Whereas individual rights, and this is again a distinction that's drawn in case law, individual rights benefit more the individual. And the entire dispute in Heller was that the majority thought that the Second Amendment was an individual right, and the dissent thought it was one that was a civic right, that was a right that people possessed, but they possessed for the benefit of society by participation in the militia. And it is a distortion of the case to say that I ever said that voting is a second-class right. That's simply not what that passage means.
But the very terms of the civic rights argument, then, the right to arms would have been treated differently than rights like the right to vote. And let's get down to the bottom line here. Heller did establish the individual right. When you finished with your dissent, here's what it came down to say. If you are guilty of a felony that is not violent, you can lose your right to vote, but you can't lose your right to buy a gun. Am I wrong?
Senator, Cantor had nothing to do with the right to vote. The point that I was making in that passage, the 14th Amendment actually expressly allows for states to deprive felons of the right to vote. And my point was that there was no similar language in the Second Amendment. I don't have an opinion and have never expressed one about the scope of a legislature's authority to take away felon voting rights. What I said is that there was a history of such provisions in state constitutions and in the federal constitution, but I did not intend, and if my words communicated that, it was a miscommunication. I have never denigrated the right to vote.
And I think it was, at best, a serious miscommunication. I'd like to read to you, in this very room, in 2005, an exchange that took place between Senator Kennedy and Judge Roberts. Senator Kennedy said, "Let's start with the Voting Rights Act. Most Americans think that the right to vote is among the most important tools that they have to participate in our democracy. You do agree, don't you, Judge Roberts, that the right to vote is a fundamental constitutional right?" Judge Roberts says, "It is preservative. I think of all other rights. Without access to the ballot box, people are not in the position to protect any other rights that are important to them. And so I think it's one, as you said, the most precious rights we have as Americans." Do you understand why I read your lengthy dissent here, where somehow or another you could say to Ricky Cantor, "Sorry, you can't vote anymore, but buy any guns you wish. We treat those rights differently." Can you see why that would be troubling based on what Justice Roberts said?
I don't actually, Senator Durbin, because I've expressly testified here that I think voting is a fundamental right, and I didn't say to the contrary in that dissent.
Well, I read it otherwise, and I read it and reread it, so I won't get that right on your final, but I will tell you, from the way I see your language, it is explicit. You have two categories of rights, one that's independent, or one that's individual, and another that is based on collective action, as in juries, as in voting as a group of the populace. And you've made a distinction there that I think is hard to understand, difficult to explain, and inconsistent with what Justice Roberts told us at this point. I'd like to move on to another. Leave it open. I want you to have the last word on this, please.
No, I'm happy to answer whatever questions you have.
Well, let me go to the poster behind me and introduce you to another family. This week I shared two stories of what's at stake with this, your nomination, ahead of the November 10th oral arguments in California versus Texas, which will decide the future of the Affordable Care Act. This is a family, and included in it is Jared Ray of Buffalo Grove, Illinois. He's on the right. Earlier this year, Jared, 20 years old, began experiencing serious headaches. After a month of suffering, he asked his father Mike to take him to the emergency room. A CT scan revealed a mass on Jared's brain, immediately transported to Evanston Hospital for surgery. Weeks later, they learned the devastating news. Jared was diagnosed with medulloblastoma, a cancerous brain tumor on the cerebellum. I'm sorry to say it's one we're familiar with here in the Senate. Senator McCain suffered from a similar situation. Post-surgery, Jared began an aggressive 6-week proton radiation protocol, currently on first round of 8 chemotherapy treatments at Lurie Children's in Chicago. His treatment costs have now added up to $700,000 and continue. Fortunately, the ACA permits Jared to remain covered by his mom's health insurance until the age of 26. That law also ensures no lifetime limits on her policy so that they can continue to give Jared the treatment that he wanted and needs. When sharing her son's story, his mom, Mary, said, "Any parent would be shocked and terrified in this situation. If the ACA is abolished and if my employer elects not to offer coverage for dependents up until age 26, that puts Jared at risk of being uninsured and uninsurable because he will clearly have a pre-existing condition." Jared's father added, "Jared would not have access to this type of care if it were not for the Affordable Care Act because he wouldn't be insured. It's been a huge benefit." Judge, last week in your prepared testimony, you said, quote, "The policy decisions and value judgments of government must be made by political branches elected by and accountable to the people. The public should not expect courts to do so, and the courts should not try." Well, thankfully, Judge, the political branches elected by the people passed and enacted the Affordable Care Act. The problem is now that the Republicans are doing everything they can to take away this protection. And they can't do it through elected officials. They tried over and over and over in the House and in the Senate. And I mentioned Senator McCain earlier in this statement. I'll never forget it, and neither will any of us who were on the floor that night when he walked through those doors at 1:30 a.m., voting no and saving health insurance of 23 million Americans. and protections for 100 million or more. They couldn't repeal the Affordable Act in Congress. Now they've taken it to the Supreme Court. It isn't a casual decision. This administration decided that instead of defending an existing law, they would attack an existing law along with the Republican attorneys general who've gathered for this purpose. They have good reason to believe they're going to be successful. As I mentioned yesterday, right-wing judicial activists have repeatedly stepped in to overturn decisions of the elected branches of government. Activist judging, including rolling back campaign finance laws in Citizens United and voting rights protections away in Shelby County. The tool of choice of these activists is the supposedly neutral judicial philosophy of originalism and textualism, which gives judges the ability to substitute their own judgment for the elected branches and to strike down and restrict laws that are disfavored by powerful special interests. President Trump has been open in acknowledging that he wants a nominee on the court to strike down that ACA. You have said you have not made any agreements or statements to the contrary, but I will tell you, it is a cloud over your nomination because he has over and over again. He's nominated other such advocates of originalism and textualism to carry out his political purposes. I'm afraid of the impact of that repeal on people like Jared. So we've been told that you're following the Ginsburg rule, no hints, no previews, no forecast. In fact, during her confirmation hearing, Justice Ginsburg did answer substantive legal questions about matters that might come before the court, such as the right to choose. Yesterday, you had one notable and selective departure from your interpretation of the Ginsburg rule. When it comes to California versus Texas, the Republican challenge to the Affordable Care Act, you repeatedly claim that the deciding question in the case is severability, not the individual mandate. That's a legal opinion. But the court will only reach the severability question if it first finds that eliminating the penalty for the individual mandate rendered the individual mandate unconstitutional. Isn't that right?
Senator, what I meant by that is that even if the mandate is unconstitutional, severability would, if it is severable, then the statute would stand. And so if the mandate is constitutional, then yes, the law would stand. But I said that the emphasis, and I've gotten a lot of questions about severability for this reason, and much of the commentary in the legal news about this is focused on severability because it means that whatever the holding is on the mandate, the severability question is the one that would be determinative, even if the mandate were held unconstitutional. So it's a descriptive. I didn't say how I would rule on severability, and I didn't say whether I would interpret the zeroed out provision to be a penalty rather than a tax.
But you see, that second part, penalty tax, you've already addressed that, haven't you?
No, I haven't. The writing that I've done before that I assume you're referring to addressed a different provision that wasn't zeroed out. This is now an amended provision, so it's a different provision before the court.
But you're on record for criticizing Chief Justice Roberts' opinion that the individual mandate is constitutional. Haven't you?
I am on record saying that I thought that the majority opinion was a less plausible interpretation of the statute than that of the dissent. Again, that was an academic writing, number one. Number two, it was on different issues than those are presented in California versus Texas. And number three, I think you're suggesting that I have some hostility to the ACA, which I assure you that I don't. And I think, Senator Durbin, there's actually something you and I agree on here. Judicial activism is bad from either side. And no matter what somebody's policy preferences are about the ACA, I completely agree with you. They shouldn't be trying to undermine the policy that Congress enacted. So you and I agree on that, and I embrace that view of a judge's role wholeheartedly.
Thanks, Judge Barrett.
We'll do Senator Lee, White House, and Cruz, and break for lunch.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to submit to the record a letter from the American Legislative Exchange Council.
Without objection.
Judge Barrett, I want to talk about religious freedom for a moment. As I mentioned the other day, I think you and I share something in common on this, an enthusiasm for religious freedom. As I mentioned the other day, I'm a member of the Church of Jesus Christ of Latter-day Saints. We have been no strangers to religious persecution, even in this country, unfortunately. On October 27, 1838, the governor of Missouri ordered us exterminated. It wasn't nice, but, I assume he had his reasons. He believed we were heretics, and I'm sure we are heretics in the eyes of many, but we try to be really nice heretics. And it wasn't until the late 70s that the governor of Missouri actually lifted that ban. I'm sure Josh Hawley, as Attorney General, would have lifted it for us had it not been lifted by then. Religious liberty has always been interesting to me for that reason, and also just as a lawyer. My late father, who was also a lawyer, worked on and advised Congress regarding the Religious Freedom Restoration Act. And my longtime professional mentor and former boss, Gene Scher, was someone who I worked with in establishing a first-of-its-kind religious institutions practice group a couple of decades ago. Catholics, like members of my faith, have also been subjected to religious persecution from time to time. And in many cases were directly targeted through so-called Blaine amendments, provisions worked into a number of state constitutions, really for, in many cases, blatantly anti-Catholic purposes. These Blaine amendments had, of course, as their purpose the restricting of public funds going to certain religious institutions, including schools. Thankfully, earlier this year, the Supreme Court in Espinosa versus Montana Department of Revenue struck another blow against Blaine amendments by reinforcing their earlier decision in the Trinity Lutheran case. Would you discuss briefly with us the Supreme Court's recent jurisprudence on this issue regarding Blaine amendments and how they intersect with religious freedom?
So the Supreme Court's recent decisions get at the principle that while, we have to be careful about the Establishment Clause, right? So there's a line of cases saying, a state or federal government clearly can't establish a church. And so we have a line of cases about what that means. But at the same time, Espinosa being an example, the court has been very clear that religious institutions can't be discriminated against or excluded from public programs simply because they are religious.
Now, during your time on the Seventh Circuit, you've been able to handle some cases involving religious freedom issues. For example, you joined a majority opinion in the Gruscott case, upholding the freedom of a Jewish religious school and its authority, its own discretion to hire teachers at its school. Now, that ruling was challenged before the U.S. Supreme Court, but the Supreme Court denied certiorari in that case. But nonetheless, a 7-2 majority of the Supreme Court in the Our Lady of Guadalupe case ended up essentially adopting a position similar to that which you joined in the case I just mentioned, in the Our Lady of Guadalupe case. Can you talk to us just a little bit about that opinion and about the Seventh Circuit opinion and its application of the ministerial exemption?
Sure. So the ministerial exemption, as you say, the court had described it in Hosanna Tabor. The ministerial exception gives religious institutions discretion to hire, and in the case of a school, teachers. It's called who are ministers. And what this gets at, or what this requires courts to do, is to decide who is a minister. And on the one hand, there may be some which you could plainly, what might be more obvious questions, like, someone who teaches religion teachers. So what the court has said is, those would follow more in the heartland. It gets a little bit more difficult if you have a religious school, like the Jewish school in Gruscott, or the Catholic school in Our Lady of Guadalupe, who has a teacher that's like, say, for example, teaching math. And then the courts have to come up with a test to decide whether such a person is a minister or not. And what Gruscott and Our Lady of Guadalupe said is it's a multi-factor test where no one factor is determinative. So it can't be determinative just that the teacher teaches math rather than religion. For example, in Gruscott, the teacher spent time teaching Jewish prayers and saying Jewish prayers with the class. And the school considered it part of the teacher's duty to form the students, to teach them about Jewish prayers and to form them in that tradition. So even though she spent other time in the curriculum teaching other matters, it viewed that as part of her job, and the school viewed her as a minister. And so Our Lady of Guadalupe gives a lot of deference to the school's characterization of whether someone is a minister or not to encourage discrimination, of course, but simply to protect religious freedom. So at a Catholic school, the teacher may teach math, but also prays with the students in the morning, attends Mass with them during the week, and is considered by the school, say in Our Lady of Guadalupe, to be someone who is also forming children in the faith. So it's really about what the scope of that ministerial exception is and how you identify whether someone is a minister.
Thank you. Thank you. That's helpful. When you came in front of this committee in 2017, we're talking about just over 3 years ago, for your confirmation to the U.S. Court of Appeals for the Seventh Circuit, you said, quote, "If there is ever a conflict between a judge's personal conviction and that judge's duty under the rule of law, it is never permissible for that judge to follow their personal convictions in the decision of the case rather than what the law requires." You still stand by that statement?
I do.
I've got some colleagues on the other side of the aisle who seem to want to focus on statements made in your personal capacity and in your capacity as a private citizen and a member of your faith, as opposed to addressing actual cases dealing with abortion. I have a hunch that this is because your record on the Seventh Circuit actually shows that you're able to set aside your personal convictions, because that's what you've done when they've conflicted with your duty under the rule of law. In Price versus Chicago, for example, I assume you remember that case. It's a case in which you joined a Seventh Circuit panel opinion affirming the legality of a Chicago buffer zone law, which places limits on pro-life activists as they're demonstrating exercising their First Amendment rights outside of abortion clinics. I assume that was the case because there was binding Supreme Court precedent on the abortion buffer zone issue. Is that right, or do you want to tell me a little bit about your reasoning in that case?
So the panel held that the issue was squarely controlled by the Supreme Court's decision in Hill versus Colorado.
So there was binding precedent on point, and so you followed that precedent, and you did so as a jurist, rather than following whatever personal predilection might have otherwise guided you or any other member of that panel. In Planned Parenthood of Indiana and Kentucky versus Commissioner of Indiana State Department of Health, you joined a dissent written by Judge Frank Easterbrook of the Seventh Circuit. And the Supreme Court later agreed with you in a 7-2 decision with respect to the Indiana law requiring fetal remains to be buried or cremated following an abortion. A position that garners a 7-vote majority on the Supreme Court these days, at least a 7-2 decision that includes Justice Breyer and Justice Kagan, does not seem very radical to me. Do you disagree? Am I missing something about that?
The Supreme Court summarily reversed, which means without argument and briefing, the panel's holding in that case that the fetal remains, the disposition of fetal remains portion of that statute wasn't rational.
And I'll note for the record here, I don't think I've ever heard anyone characterize as a radical act of conservative activism a 7-2 decision joined by Justice Kagan and Justice Breyer. Judge Barrett, in addition to being able to set aside your personal convictions when deciding a case, you've also demonstrated the ability to expertly determine what the law requires. This stems, I believe, from a fundamental and, I believe, correct view that a judge needs to start from the premise that the law provides an answer. The fact that legal disputes can be difficult and reasonable minds might disagree as to them doesn't excuse the judge in believing that there is a right answer. And you seem to follow with that, and it shows up in your work in a way that reflects very well on you. The Congressional Research Service conducted a review of your cases from the U.S. Court of Appeals for the Seventh Circuit and determined that your decisions, and this is a quote, evince case-by-case consideration of the relevant law and facts without any clear overarching trend toward either expanding or narrowing Fourth Amendment protections, close quote. Now, this is exactly what I would expect from a textualist originalist on an issue that, like the Fourth Amendment, can actually be politically charged. But with the textualist originalist, this is exactly what you'd expect to see, somebody who doesn't appear to be a partisan one way or another and comes down on both sides, on the government side and on the non-government side. This would also account for a variety of outcomes in your cases, because you're not aiming for an overarching trend in outcomes. Your analysis seems sometimes to come out in favor of a defendant, and sometimes in favor of the government. I find your dissents and your concurring opinions in panel decisions to demonstrate this commitment to following the law as it's written, rather than on the basis of some external objective. Can you tell us why you felt the need to dissent in the case of Schmidt versus Foster?
Yes. So Schmidt versus Foster involved a state court case. It came up through the Wisconsin courts. And in the case, there was a question of whether the defendant could raise a defense under Wisconsin law called adequate provocation for having murdered his wife. The case wound its way through the Wisconsin courts, and the defendant argued that an ex parte examination of the judge at which his counsel was present but not permitted to speak did not violate the Sixth Amendment, because in that case, the defendant, they didn't want to preview his case for the prosecutor, and so he didn't want the prosecutor in the room. So the judge said, well, I will allow that, but only if your attorney doesn't speak, because, if we're not going to preview your case for the prosecution and not permit the prosecutor to be here, that was how he's going to do it. So then the judge proceeded to ask the defendant questions to decide whether he could make an adequate provocation defense, and concluded that he could not. In that case, the Wisconsin courts held that this proceeding did not violate the defendant's right to counsel, this, telling his counsel that he couldn't speak. It came to my court under 2254, which is the state habeas statute permitting collateral review of state convictions. But EDPA requires very heavy deference to state courts. You can only disturb a state court holding, for example, on a matter of law, determination on a matter of law, if no reasonable jurist could reach that conclusion, or it has to be in conflict with clearly established Supreme Court law. And in that case, I made clear that it wasn't up to us to decide whether we thought as an original matter, just if the case had just come up before us, whether that violated the Sixth Amendment, because as the panel majority, which then became a dissent when the case went en banc, said this was an unprecedented kind of hearing, which, if it was unprecedented, meant that there was no clearly established Supreme Court law on point. So the decision in that case was driven by federalism and by the statutory instruction that federal courts give deference to state courts.
Thank you. In another case, United States versus Wilson, I believe that was a case in which you agreed with the majority in concluding that the officers acted with reasonable suspicion based on the circumstances of the case and the detention there involving flight by the individual from the scene. But you wrote separately. Tell us why you wrote separately in that case.
So that case, if I have the case correctly, so I've been almost 600 cases, but I think I know the case that you're talking about. I think that was a case where police had a tip about some criminal activity, and there were a group of men in a park. The police approached the park, and then they went up to talk to one of the men at the park because they noticed a bulge in his pocket. He was wearing gym shorts or some sort of athletic shorts that showed a bulge. And the police approached the man, and he fled. And under Supreme Court case law, the determinative question for a seizure is, whether the person fled and then was detained, then seized by the police. The other way that could have been justified is if, as a matter of a Terry stop is the case, the police had reasonable suspicion to approach him just because they saw the bulge in his pocket. And I wrote separately because I thought that the policeman's basis for stopping him, if this really had just been a Terry stop based on reasonable suspicion, was questionable because they really had, they had an anonymous tip. The people in the park didn't match the description of the description given in the anonymous tip. All they saw was a bulge in the pocket. So if he had not fled, I thought the case should have just talked about the flight, because if he had not fled, I was pretty dubious that would have been a justified stop.
I admire your decision to write separately in that case. I think that shows real courage and moral and judicial leadership to speak out and write separately when the occasion requires it. And you did so here with nothing to gain from it. You did so because it was important to point that out under the law, and I respect that a lot. In the couple minutes we've got left, I wanted to ask you more broadly about something I've noticed in reviewing letters and other materials we've received in response to your nomination. I've noticed that there's a common theme among your law clerks and your students. They feel like you see them as individuals, and they feel mentored and taught by you. Tell us a little bit about that. I'd love to hear, for example, how you go about deciding who to hire as your law clerks, and how you mentor them as they go through their year studying with you.
So over my teaching career, I've taught roughly 2,000 students. And now I have, as a judge, 4 law clerks per year. And then I also continue to teach at least a seminar in which I have like 15 or so students usually. And, what I'm looking for in a law clerk, of course, is, excellent legal ability, because I need the help, to do the legal research and all of that sort of thing. So I want someone who has excellent legal ability. I want someone who has integrity. I want someone who isn't afraid to push back and express his or her own opinions, but at the same time realizes that, I am the boss, and if I disagree, then they're going to have to go along ultimately. But I also want clerks who are, and this is part of the integrity, who have character. Our chambers is small. If someone had, say, sharp elbows, in a chambers that only has 6 people, my assistant, the 4 law clerks, and me, or that showed disrespect or arrogance, that would make for a pretty miserable year for everyone. And I've not been disappointed. Every one of my law clerks has fit that bill. And so I view it as my duty with my law clerks, much like with my students, to encourage them to enter the profession as full people who hopefully have gained some knowledge of the law in their time with me, and also seeing how they can, live a life where people can disagree without being disagreeable.
Thank you, Judge Barrett. I see my time's expired. Thank you, Mr. Chairman.
Senator Whitehouse.
Thank you, Chairman. Judge Barrett.
Senator?
First, if I may, Chairman, let me ask unanimous consent that an essay I wrote for the Harvard Journal of Legislation called Dark Money and U.S. Courts be admitted to the record.
Without objection.
That a report that Senate Democrats prepared called Captured Courts be admitted to the record. and that an article by Christopher Leonard in the New York Times called Charles Koch's Big Bet on Barrett, describing his activating his political network to support Judge Barrett's nomination, also be entered to the record.
Without objection.
Thank you. Judge Barrett, on the Seventh Circuit, you are subject to a code of ethics, are you not?
I am.
And I presume you are okay with that?
Of course.
In fact, I would submit you probably think that's a good thing.
Yes.
And indeed, it is true of all the circuit courts that they're subject to pretty much the same code of ethics, correct?
Yes.
It gets different at the Supreme Court. Supreme Court is not subject to a code of ethics, is it?
The canons of judicial conduct that apply to lower court judges do not apply to the Supreme Court, although I do believe it's the practice of the Supreme Court to follow them.
Yeah, they do not apply, we agree. And indeed, going to the Supreme Court can interrupt an ethics investigation, as we saw with Justice Kavanaugh, who had an ongoing ethics investigation in his circuit that was interrupted by his elevation to the Supreme Court without having concluded. Let me first ask you, there's no such thing with you, correct? We have no Seventh Circuit ethics investigation going on that would be interrupted by your elevation to the Supreme Court.
I'm not aware of any ethics.
I suspect you would be, so good. We can put that behind us. With respect to reporting of gifts, of travel, of hospitality, of what the constitutional might call emoluments, all of the circuits have a pretty solid rule about reporting those, and you comply with that rule on the Seventh Circuit, do you not?
I do. It might even be by statute that we have to do that, but I do.
Yes. And the rule, I don't know how familiar you are with this, so I'll offer this as a proposition. The rule that you follow and the way in which circuit judges follow it aligns quite well with the reporting requirements that in the executive branch members of the cabinet have to do when they get gifts, travel, hospitality, and other emoluments. And it aligns quite well with the reporting that members of Congress have to do when we get gifts of travel or hospitality or other such emoluments. The discrepancy here is with the Supreme Court, which has a much lower standard of transparency and disclosure about those very same things. So it's a bit of a mystery when I see the situation that when you go up to the court, you will be not subject to the code of ethics that you're subject to now or any other, and you will have lower reporting requirements than you do now or that any of us do. And I flag that for you because I think it's anomalous that the highest court should have the lowest standards. And I don't know if you want to say something about that. At a minimum, I hope you'll keep an open mind about trying to fix that when you're on the court. If you have a defense of why the highest court should have a lowest standard, have at it now.
I didn't know. I know that the justices file financial disclosure reports. I've never looked at one. I didn't know that they were different or that it was a lower standard from the ones that the rest of us
Okay,
file.
well, take a look at that when you get up there. This is a matter I think that the court handles administratively.
I've never interrupted anybody, but can I just ask one question?
Of course.
Now that you know that, how do you feel about it?
That the
Does that
Supreme
stop my
Court-
time while you're answering the chairman's question?
Time, but I think it's a good question. Now that you know, how do you feel about it?
I guess, as I just said to Senator Whitehouse, I'm surprised because I did think it was by a statute that applied to everyone. So I'm surprised. I've always complied with filling out my financial disclosure reports. And as I'm sure it may have been for you all, it's a little uncomfortable the first time to make your finances available. Anybody can request it. But I've always complied.
For the record, it's a question of interpretation and practice. And Senator Graham and I have actually had public conversations about trying to remedy this with a legislative fix. So you've got that potentially coming your way. So I flagged that for you. The second thing, another topic I'd like to raise with you is you've repeatedly mentioned during this hearing